Moving on to referrals. Mr. Clerk, will you please read in Communication 277.7?
Communication 277.7, request for Corporation Counsel update on the Missler ruling, including whether or not it will refrain from appealing said ruling as advised by Resolution number 114-13, adopted by the Council on May 15, 2013, from Council Member Margaret Willie, dated July 24th, 2013.
Thank you, Mr. Clerk. May I have a motion to close file on Communication 277.7?
So moved.
Second.
We have a motion by Ms. Willie and a second by Ms. Ford. Any discussion? Ms. Willie?
Yes. This is a follow-up from our earlier resolution asking the Corporation Counsel to please embrace the Ibarra decision, not appeal it. And I think just for the public's information, a lot of this was what is the authority and power of the community development plans, and also the public trust and precautionary doctrine, and how does that apply, and whether those considerations are considered on both public and private land. Judge Ibarra basically ruled against the county's position and in favor of, and I'm simplifying here, the authority of the CDPs, and also ruled that the planning department did need to apply the public trust doctrine in terms of the watershed that was at issue. In terms of the specifics on that, I expect Ms. Ford will probably bring up some discussion. But our concern was, I guess I should say, my outrage is, how can we possibly be appealing this? And I think that in terms of the legal issue here is who is the real party of interest, where it's the county and it's the director of planning and the Board of Appeals supporting the planning director are each named as the planning director as part of the county, the Board of Appeals as part of the county. So my understanding is that the Board of Appeals is either intending or still considering or has said that it wants to appeal, and that it has the right to appeal regardless of what the county council as the policy-making body of this of the county. So therefore I've asked Lincoln to come forward and educate us as to what is the status, and I think I want to say that our council addresses litigation such as where, because we are in charge of the purse strings as well, if attorney fees are claimed from the other side that we lose, I think that would be coming out to the county. I, for one, would say if the Board of Appeals is going to be a rogue Board of Appeals, then be happy to pay those attorney fees. So I just think we are one county, and I know there's some difference of opinion between the administration in terms of support of the CDPs. We as a county council have taken a very strong position supporting those plans and trying to give local government a little bit more say-so. And I just want to add one thing, is that why are the CDPs important? I think the public needs to realize that our first layer of official government is the county. That means we don't have towns, we don't have villages, that this is the one place that really each district can have some say-so over what happens to them. So I'm going to yield. I do have, I just want for you, Lincoln, to go ahead and sort of make it a statement, and maybe there's been an epiphany and we're all on the same page now, and this is totally waste, unnecessary, but it is of great concern to me. Thanks, Lincoln.
Good morning, Mr. Chairman, members of the committee. Thank you, Ms. Willie, for bringing this communication forward.
Mr. Ashida,
yeah.
please identify yourself for the record.
I'm sorry, Lincoln Ashida, Corporation Counsel. Thank you, Ms. Willie, for submitting this communication as an update. You are correct. Your statement earlier about both the planning director and the Board of Appeals being the real party in interest in this matter. After the council had passed this resolution, it was presented to both the planning department as well as the Board of Appeals. The Board of Appeals heard it at a duly noticed one of its monthly meetings and has decided as the real party in interest to pursue an appeal of this case. My understanding is the necessary documents seeking to perfect an appeal with the ICA and subsequent to that the Hawaii Supreme Court. Those steps have already been undertaken. I wanted to comment, Ms. Willie, on one thing you did say. You are correct that the Board of Appeals and the Planning Department are the only two named parties and parties in interest. You mentioned about the council's authority. You are correct. However, if you look at the code, the council's authority is for settlements or any types of compromises which require payment in excess of $1,500. That makes sense. For example, if the county is banged with a big verdict, let's say $1 million, I mean, you cannot vote not to pay that. It's a decision. So really, when you talk about council's authority in settling litigation, we're talking about situations where there's going to be a compromise, and we are compromising or settling in excess of $1,500. Generally, litigation decisions like this, especially the decision to appeal, and that's well documented in the Chun case, it does lie with the real party in interest, and in this case, that is the Board of Appeals, and that is exactly what we did. I really want to thank you for giving me this opportunity to address the committee, because the undercurrent and tone of all of this is somehow it's either my decision or our attorney's decision, and that's what's driving this. We're just the attorneys here. We are obliged under 1.2 and 1.3 of the Rules of Professional Conduct to zealously pursue and abide by what the client directs. In this case, the Board of Appeals has done so. Our decision, in other words, I don't think it's correct to say that, to cast any aspersion that, myself or any of our attorneys have any predisposition regarding the specific merits of a PUD or the underlying issues. Our job, our responsibility is to pursue any viable claim, defense, or otherwise a remedy available to the client. And that is not only something that's expected, but it's demanded by our rules, and that was done in this case. So I thank you, Ms. Willie, for giving me the opportunity to say that, because that was something that I kind of wish I said the first time when we first addressed this resolution, to let you know that when our decisions are purely based upon what the client advises, and as long as it's lawful and ethical, we're obliged to follow that path, and that's what we did in this case. So thank you very much.
Okay, I want to clarify something that, if I was not clear, I do not agree that it is this volunteer Board of Appeals that is the real party of interest. Okay, so we differ. Yes, the Chun case says it is the decision of the real party of interest, whether it's the county and they are an entity of that. I completely disagree that they have. And let me just say, I've been through appeals or dealing with the Board of Appeals, and the Corporation Counsel plays a major role and does advise. Here it is. I mean, it's not just, okay, what do you all think? It's, here it is. Do we honor this decision or do we not honor it? So it's, I realize whether the administration, when we had the Charter Commission hearings and I tried to get the CDP memorialized in them, it was the administration, and you spoke on behalf of the administration as well as Bobby Jean, saying basically, and taking a more negative attitude towards them. So I feel that part of this is that difference, the counterbalancing between the legislative branch and the executive branch. And I'm not saying there isn't room for differences of opinion, but I do feel, I haven't seen, I tried to find the minutes of that meeting where this was discussed to sort of see how it went. And I know you represent us, our branch, and you represent the executive branch at the same time. But I just want to be clear, I don't see that the Board of Appeals appointed members that we confirmed, but appointed by the mayor, volunteers, coming in and saying, well, despite this opinion of the judge, and also despite the Kauai Springs case with a similar ruling on the public trust doctrine, which was decided 5 days later, well, we've decided we want to appeal. I just find it outrageous. So I think, that maybe on its face it looks like, oh, we're just the attorneys and they told us they want to appeal, so we're doing it. It just doesn't ring true to me. So I know there are differences of opinion. I just want to express mine. It's something that's important to me. And I tried to take the position that I wasn't getting into who has the authority. Do we as the council have authority? Who has the council? And just have an adult conversation and assume they would make an adult decision. And I just don't see that here. I mean, my question is, maybe we should be bringing in amicus brief on behalf of the Misslers for doing something on behalf of the council. So anyway, I think it's unfortunate, the decision that was made, and I appreciate your explanation as to how you see it. You see them as the decision maker, and whatever they say goes. And there's no definitive law on all of this, but I see the legal, who is that party of interest is not up to this board to make that decision. Thank you. I don't know if you want to respond to my difference, but I respect our difference of opinion, but I think you know where I'm coming from.
Thank you, Ms. Whitting. Ms. Ford, just before Ms. Ford gets started, I just want to make sure that we're keeping our conversation strictly to the Missler case. So this is an update from Corporation Counsel on this. With that, Ms. Ford, you have the floor.
Thank you. However, part and parcel of the update is the fact that I agree with Ms. Willie. The Corporation Counsel has chosen to appeal a case and in violation of the charter of this county. The parties of interest, and I disagree with Mr. Ashida and all of his staff if they concur with him, parties of interest is not a voluntary board of appeals. They have no legal right or capability of authorizing the expenditure of funds, period. Neither does the planning director have any authority or right to expend funds in a case or even a settlement. Neither one of these agencies has that right. They cannot be the party of interest. I will tell you, of course, as usual, I had to go outside to other attorneys, and we specifically discussed the Chun case. The Chun case was where a party, I think it was a state attorney general who filed an appeal, was not a party of interest. And that's what the Chun case proved. They were not a party of interest, and they couldn't make the appeal. So you have a voluntary board and a planning director who has no authority at all, by charter, code, anything, to handle an appeal. The only persons that can handle an appeal for this county is the Office of Corporation Counsel. And they do that only by our authority. There is nothing in the charter that talks about appeals. Nothing. If you look into section 2-2 of the charter under exercise of powers, I will read this into the record. All powers of the county shall be carried into execution as provided by this charter. Or, if the charter makes no provision, by ordinance or resolution of the county council. Guess what? we're the county council. We did this. We said, do not appeal by a resolution. And yet the appeal went forward. Mr. Ashida, would you like to explain why you are not in violation of this charter?
I don't understand why we are in violation of the charter.
We sent you a resolution that said don't appeal.
That's correct, and that was presented to the Board of Appeals.
I really, Mr. Ashida, I do not agree that the Board of Appeals or the planning director has any legal right to settle a case or authorize an appeal. They are not a party of interest. I'm asking you why your office violated this charter and by a resolution when we said don't do this.
Ms. Ford, it's difficult to answer your question because you're asking a loaded question.
It is loaded.
And I disagree with you. So I'm not going to agree with your premise. Your premise, in my opinion, is flawed.
Did I just read this correctly out of the charter? I read it verbatim. Unless it's in the charter, you can't do it unless it's by ordinance or resolution of the council. There's nothing in here about appeal. Nothing.
I don't believe that. I believe that that is a mischaracterization of the authority, the vested authority of our office with respect to our powers within the charter. What you're suggesting is just because it says that it doesn't say something in there means we can't do it. Frankly, that's not the way it works.
You can do it if you have the authority of the council, and we told you not to do it. We told you not to do it.
I don't
That's the
disagree
end of
with
the
that.
subject. The Chun case says you have to be a party of interest.
Well, actually, your recitation of the facts of the Chun case earlier were actually incorrect.
Go ahead.
The Attorney General was never a party of interest. They were the advocate in that case. I believe it was the ERS board, which was the proper party of interest.
And the
But the
ruling
bo-
said they weren't a party of interest, it was the legislature.
The bottom line, Ms. Ford, is in this case, we did our due diligence. When we were confronted with this issue and after receiving the council's resolution, we checked with the Hawaii Supreme Court's Office of the Disciplinary Counsel, and they advised us that under 1.2 we were obliged to file an appeal in this case. So we exercised our due diligence, our duties pursuant to the rules of professional conduct. I didn't want to bring that up here because I appreciate the discussion that we're having, but truth be told, that's exactly what we did, and 10 out of 10 times we do the same thing.
All right, let me ask this question. Ms. Willie brought up a very good point. Is your office prepared to write an amicus brief in defense of the judge's decision?
No.
So you only represent the planning department, the director, and the Board of Appeals. You don't represent this council at all.
You are not a real party in interest in this particular case.
We are, because you violated the planning director violated the CDP and the public trust, everything else, and that's what we're here to uphold.
Okay, Ms. Ford, if what you're suggesting is this council collectively wishes for some reason to involve itself as an amicus party, ask permission or ask leave of the court to file an amicus pleading, number one, there's a question whether that is actually within the scope of your authority, whether you are a real party or interest or not. Assuming that you are and you wish to go down that route, for one thing, I don't think you are, but assuming you want to go down that route, you're fully free, if you can get 6 votes, to hire special counsel in this case to go look at that and pursue that. But I don't believe that that type of amicus assistance is going to be forthcoming from our office. Ms. Willie also made a statement earlier that I think she was, if given the benefit of reflection, she would reconsider her statement about filing an amicus party on behalf of the Misslers. Clearly, we would not authorize or advocate for the expenditure of government funds to fund any private interest in litigation. So I trust Ms. Willie is knowledgeable enough to know that that was just probably a misstatement on her part. But turning back to this council, again, in my mind, it's very clear that the Hawaii County Council, as an organizational body, is not a named party in this action. You've expressed your collective opinions concerning the future course of this litigation. You did so via resolution. It was presented to the real parties in interest, the planning director and the Board of Appeals. They made the decisions in this case, which we verified through the Office of the Disciplinary Counsel, and that's where we are today. If, like I said, if you collectively, a majority of you feel that you want to go down the road of filing an amicus brief or asking leave of the court to file an amicus brief in this case, I would caution two things. Number one, consider whether you are, that is within the course and scope of your duty as council members, number one. And number two, it's going to have to be done via your powers and authorities to hire special counsel. And at present, I could not advocate for that.
Thank you for your opinion, Mr. Ashida. When you, did you write to the ODC or did you just talk to them?
We wrote to the ODC on related matters, but with respect to the direction to pursue the appeal, one of our attorneys had direct telephonic contact with them.
Okay, so did they send back a written estimation of what you're doing here? I mean, did they give you a written reply or did they just give you a verbal? We don't know what the question was asked or how it was phrased. But, you know, when I look at this case and I see the breach of the public trust, I'm not talking about the Misslers. I'm talking about the CDP that's been violated, the public trust that's been violated, all these things that violated. It's not about the Misslers. It's about the county's consistent, strike that word, the county's inability to follow the laws that we have on the books. And all of these violations took place all in one case. It's not about the Misslers. For me, it would be an amicus brief to defend the public trust and the CDP, that we are a party of interest because we set the laws. We're the ones that vote for these laws, and they have been violated. The state, of course, does the public trust. We have an affirmative duty, according to this case, we have an affirmative duty to protect the public trust, and I don't see that happening. Certainly the Board of Appeals isn't doing it. The planning department, the former planning director was not doing it. Nothing in Corporation Counsel indicates that you're helping in this matter, except to support them to continue to violate the public trust and violate the CDPs, and in my opinion, violating Section 2-2 of the Charter with deliberation. With deliberation, Mr. Ashida. I know that you and I don't agree on this. I understand that. I accept that. But, you know, when you sit there and tell us, oh, counsel, don't go down this path, we don't have an attorney representing us.
Please summarize this one.
We do not have an attorney to represent us in this matter. And you're telling us, oh, now we got to get a special counsel by a vote of 6. After we sent this resolution, I yield.
Mr. Onishi?
Oh, can I respond to that?
Yes, you can respond to that and then Mr. Onishi.
You know, I agree, Ms. Ford, that we can disagree. And I think having a healthy discourse and discussion can be a very healthy thing. But, you know, I believe a lot of your statements were very accusatory and had very conclusory statements made which aren't supported by the record or fact in this case. You know, first of all, you know, when you talk about you're not being represented, part of representation presupposes that you are a real party in interest in the litigation. Okay? And, you know, like I said, if the council feels that they want to go down that road, I'm not here stopping you. Okay? If you have the authority to hire special counsel in this case, if you want to deliberate and debate that, the council is free to do that.
Can we do it without you being in the room?
I don't understand. I don't understand why, you know, you keep complaining about that. Why not do something about it? Secondly, you know, I think I have a little more confidence, perhaps, in the judicial process. You know, I've litigated cases, you know, for a long time. I've always had confidence in the adversarial system and a good, just result coming out at the end, even if, you know, persons or people involved in the litigation or onlookers may not agree with the result. I think there's a certain integrity of the process that, you know, I find, at least as a lawyer, very comforting. And I often get a little, I guess when the hair stands up on the back of my neck is when you say, well, don't let the court decide it. Don't let an appellate court decide it. I want appellate courts, especially the highest court in our state, to hear important legal issues and give us guidance, give the whole state guidance on what it means. I'm not going to be combative in my words to you, Ms. Flores, but I guess my rhetorical question is, what are we afraid of? Let a Supreme Court in our state decide issues of significant, not only county, but statewide concern. Give us the guidance. I've always been a tremendous advocate of that. I've always found that to be, at least as a lawyer, very comforting. To have the abilities for that type of thorough legal discussion, analysis, research, and the decision making by those justices in our state. So, I guess I would ask, I agree, Ms. Ford, we can agree. I just hope that moving forward in the future that we can agree, at least a little more civilly, without those types of accusations that are just not based in fact and really have no place before this Hawaii County Council.
I'd like to respond.
You've yielded, he's responded.
Oh, good.
I'm going to have Mr. Onishi, if there's anybody else that has not had a chance to speak, and then we need to wrap up discussion on this. I feel that we have the update, that was clear, and we're going to just be pushing into time. Everything's going to get pushed back. And that's fine, you introduced it, we'll do that. So, Mr. Onishi?
Yeah, no, and to my understanding is that that's all we wanted to get, is to get, I guess, a clarification or more of a guidance of, or make it more clearly on what the ruling was all about. And that's what the department wants to know, and then we can move forward. But also, to me, in my opinion, a resolution is done where we asking for the administration to follow our ideal, but it's not where they have to do it. It's not where it's a forced thing, you need to do this, or you shall, like how people use the word, right? So we need to kind of understand, or we need to kind of sometimes listen to what we say, because in other issues you say one way, and in other issues you say the other way. So to me, you just need to be more consistent. And so that's how I, listening to all this discussion, and I think that's where people, I guess, need to kind of think about it. Thank you.
Thank you, Mr. Onishi. Ms. Willie?
Yes, I believe there's only two entities that have the power to sue here in this state. One would be the state, and one would be one of its subdivisions, which is the county. In this case, we are equating the Board of Appeals with the county, and I think that's wrong, but I made it clear. Let me say, I'm not in favor of our council going and writing an amicus brief, and it would be an amicus brief in support of the county that would be in support of the position taken by the Misslers. It's not writing amicus for the Misslers. The County of Hawaii tends to be the one that ends up in litigation and ends up losing. And I think it's great hearing, allowing the courts to act. But I just find this outrageous. I do agree with Councilmember Onishi. I did do it as a resolution. And I didn't do it where I was saying because we don't have the power. I said, I want to just do this. Let's have a conversation. We've got a legislative branch, executive branch, and work together on this and make the right decision. So again, I just want to end with the point that the legal entities, an entity that has the power to bring the suit, I would assume it's going to say Board of Appeals of the County of Hawaii. I think you ought to take that off. Just say Board of Appeals, let them go out and do it, because it is not, you cannot equate that Board of Appeals with the legal entity of the County of Hawaii. So I'm am very upset about this. I don't feel that we as the council should be filing a lawsuit, and I'll just remain, this is not how we should be using our funds. I think that perhaps from now on, members of these boards, it should not be the mayor reviewing and coming in and asking for a yes or no vote on who was appointed. I think perhaps it should be in consultation with us. I just find it that people on the board can have the audacity to think that they should go ahead and say, we want this challenge, and expect the corporation council to jump. Thank you very much, and thanks for the opportunity.
Yes, Ms. Ford, you can have, I know you have more times. I think just for the sake of trying to get through this discussion and for the people here in the audience for the other bills, just try to do the best we can to get it done. Thank you.
Thank you. I'll try to keep this short. First of all, this is not about being afraid of the ICA or the state Supreme Court. I personally believe that they're going to uphold the decision of the court, and I think we're going to get our rear ends kicked again, and I think it's a waste of county funds to do this. We have a planning department that has historically been very contemptuous of the CDPs. We have a board of appeal that rubber stamps everything that the planning department wants. And I'm saying planning department generically. I don't mean all the respective individuals of the planning department for whom I have great respect. However, I do say that we should do something about this. I think it's, from my perspective, the reason this is being appealed is to delay having to follow the judge's rule. This potentially gives the planning department the right to continue to violate the CDP, the various codes, the public trust. It'll delay this, could be years before this is actually resolved by the court, and that's what I wanted to avoid. Stop spending the public's money on things we're going to lose in court. It's going to create a larger debt for us to have to pay off. And some of us, and all of us, may not be here when that happens, so I realize that we're not personally liable for this, but I do hold Corporation Counsel personally liable for the fact that this expenditure of unnecessary funds is about to occur. And we'll just have to see what a judge says, another judge, because we keep losing, we're going to lose some more.
Mr. Grant, can I follow up on that last
Yes,
statement?
Mr. Chu, yes. Try to make it as brief as you can.
Yeah, I just one question. Ms. Ford, what cases are you referring to, the other cases that we have lost?
You know, Mr. Ashida, you can't, every time we talk, you come in and ask that question. You go do your research and stop asking me to do it.
Well, we have, and we are not able to locate any of those cases going back 10 years. All the final appellate court decisions, except for one in 2001, were returned in favor of the county. So what particular cases are you referring to?
Mr. Ashida, I'm not on trial here, and I've told you that about 6 times in the last 6 years. Thank you.
And I would ask that you make accurate recitations on the record concerning your repeated comments that we keep on losing cases, because, like I said, we went 10 years back and there's only one case in 2001 that was resolved not in favor of the county, but all others were. So I just make that as a friendly request, Ms. Ford. Thank you very much.
Ms. Poindexter?
Yeah, I just want to say that thank you for coming forward to give us the update on the Missler ruling, just exactly what this says. It's unfortunate that it turns into a battle of, it's like people on trial or making accusations, or, because this is publicly, it's televised publicly. So I just don't like when we give these perceptions or accusations and the hundreds of people are watching this, and we ourselves are causing this divisiveness within our own county of Hawaii, which the Corporation Counsel represents the county of Hawaii. They don't represent us as a body, then they go represent the administration. We're not all different. We are one. We are the county of Hawaii. So I don't like the separations that we ourselves create that perception for the public. So I apologize if I ever did, create a perception of division. We are one county of Hawaii. Aloha.
Thank you. Any other discussion? Seeing none, take a voice vote to close file. All those in favor? Aye. Any opposed? Okay, 9-0. Communication 277.7 is closed. If there's no objections, I'm going to take communication 358, Bill 102.